I'm Dr. Kalpana. In this lecture, we are going to learn a very important topic of constitutional law of India, which deals with union and its territory, the study of Article 2, 3, and 4 of Indian Constitution. This is a kind of an academic discourse for law student and constitutional scholars. Territories of India can be changed, altered. So there is a kind of introduction to the constitutional framework related to three aspects: admission of new states, formation and reorganization, and alteration of boundaries and names. So Indian constitution provides a flexible and dynamic structure to accommodate territorial changes within union. Article 2, 3, and 4 establish the constitutional framework for these three aspects. Number one, admission of new states. Number two, formation and reorganization of states. Alteration of boundaries and names of the states. And these provisions ensure India's sovereignty and integrity while allowing for necessary reconfigurations. Now, coming to Article 2, which deals with admission or establishment of a new state. Text of the Article 2 says Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. Meaning, thereby, Parliament is only having power to admit new states. No state government has that power. Now, coming to the scope and authority, Article 2 applies to territories not part of India. At the Constitution's commencement, only Parliament has this power. Now, coming to the terms and conditions, Parliament can impose specific conditions such as political autonomy, language protections, etc. Illustrative examples are Sikkim was admitted as a new state in 1975, Goa, Daman, and Diu in 1961 were admitted as new states to the territory of India, exemplify its application for external territories. There's one case, Pradeep Chaudhary versus Union of India, which comes from 2009, reaffirmed Article 2's application to territories not originally part of India. Now coming to Article 3, formation and alteration of existing states. So text of the Article 3, Parliament may by law can form a new state by separation of a territory or uniting existing states, increase and decrease the area of a state, alter the boundaries of any state, and alter the name of any state. So there are four powers have been given by Constitution of India under Article 3 to Parliament of India, means union government has that power. So proviso of Article 3, no bill can be introduced without President's recommendation and consultation with concerned state legislatures. State's opinion, however, is not binding. Key aspects of Article 3 that applies to existing states, unlike Article 2, Article 3 exclusively governs the internal reconfiguration of a state already within the Indian Union. Parliament's wide powers. Parliament possesses extensive authority to reorganize state territories without necessitating a constitutional amendment article under Article 368. Consultation, not consent. While President must refer the bill to the state legislatures for their views, their consent is not prerequisite for Parliament to proceed. Major applications which history has witnessed in India, Article 3 has been instrumental in numerous significant territorial reconfigurations throughout Indian territory. Andhra Pradesh Reorganization Act 2014, which is a recent, led to the creation of Telangana. State of Bombay reorganization 1960 bifurcated into Maharashtra and Gujarat. Before 1960, Maharashtra and Gujarat happens to be one state. New state in 2000 were created. Uttaranchal, that is now Uttarakhand, which separated from Uttar Pradesh, Jharkhand and Chhattisgarh. Jharkhand separated from Bihar, whereas Chhattisgarh separated from Madhya Pradesh. Important case law on Article 3, Babulal Parate versus State of Bombay 1960 affirmed that opinion of a state legislature is not legally binding on parliament regarding territorial changes. Berubari Union Case 1960 crucially distinguished between internal reorganization Article 3 and cession of Indian territory to foreign state, which requires constitutional amendment under Article 368. Union of India versus Surya Narayan Yadav, that is a case coming from 1985, reiterated that Parliament's power under Article 3 is sovereign and cannot be vetoed by state legislature. Now coming to Article 4, laws under Article 2 and 3 are not constitutional amendments. Text of Article 4 says, any law referred to in Article 2 or Article 3 shall contain such supplemental, incidental, and consequential provisions such as law shall not deem to be an amendment to this Constitution under Article 368. Implications of Article 4 schedules amendment. Laws enacted under Article 2 and 3 can amend first schedule state and union territories and fourth schedule Rajya Sabha seats. Simple majority rule. These laws do not require special procedure stipulated under Article 368, enabling passage by simple parliamentary majority. Consequential provisions include provisions for Rajya Sabha representation, allocation of assets and liabilities, ensuring seamless transitions. Now coming to the comparison of the summary chart of Article 2, 3 and 4. Article 2 applies to external areas, whereas Article 3 existing Indian state, Article 4 under Article 2 and law under Article 2 and 3. Who acts? Article 2, Parliament is empowered. Again, all the three articles, Parliament is only having power to legislate for these purposes. Consent of the state is not required in any of the case, either it's Article 2, 3, or 4. Only they are sent for consultation, and that is not binding. Constitutional amendment needed? No, no, no. Now to conclude today's lecture, Article 2, 3, and 4 reflect the vision of a strong, adaptable union. Constitution makers foresaw the need for territorial adjustment to address evolving political and ethnic realities. While these provisions centralize power, they have facilitated national integration, administrative efficiency, and democratic representation. Thank you so much. Happy learning.